Bello ICT. Hello, Bello ICT. I think it's okay.
Please kindly be seated. There will be time enough for photographs and salutations after the ceremony. Please kindly be seated. Shh. Please, can the hall be silent? Please, those at the back, we are waiting for you to please sit down. Please, those at the back of the hall, please sit down. Those at the back of the courtroom, please sit down. They don't fear anybody. So that judges, somebody stand here, they will be a bit, they are not even listening. Please, let's be seated. Please, let's be seated. Distinguished conferees, please be seated. Olumide.
Old form. No, his seat was donated.
So I think this should be the extra. Maybe it's inside.
He said the 7 names that I typed on.
And we typed for everybody. Did he collect?
This is for Ayola Olufemi.
But him too, he didn't collect when people should.
No, we just kept it on the seats.
Distinguished conferees, your oath form should be on your seat or on your table before you. Please keep it near to you because that is the first item. Thank you. Well done, sir. You're welcome, sir. You're welcome. Please, let's be seated. This is a final call for us to be seated, please. Distinguished conferees.
My president. How are you? For you? Yes. Oh. And you also.
Sound test. 1, 2, 3.
Before the season start now, some of them they will even leave it there.
Check one, two. Check.
Okay, they are open.
Sound test. 1, 2, 3.
I got one space.
Wait. Do you have a share? Do you have a share?
No, I don't.
You don't have a share. Please, can I see you that side so that I will arrange something? Oh, one. Kalaka. Kalaka.
Congratulations again.
Thank you.
Our son took your wife first. Yes, I couldn't make it, unfortunately. That day I turned 50.
Yes.
So my family members held me bondage in the house.
Good. It's good.
But our prayers are with him. Congratulations. From there.
Mr. Motunde, can you excuse the woman to leave, ma'am? Mr. Motunde, can you excuse her?
I'm only trying to ensure that.
Madam, why don't you get shares? Or two.
Excuse me, sir. Sorry. Excuse me.
At midnight.
Sorry. Please, all the conferees, can you just be on your chair and sit down? You will take a lot of photographs. Excuse me. Excuse me.
Sorry.
Excuse me. What are you doing here? 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 Eh? You want to put other people in trouble. When they will be paid, you people will not be paid. Eh? No. Don't open the door again. Don't
You see, they are dogging, they are opening it from outside. He doesn't have key.
I told them it's outside.
I was the one that brought them back. I was the one that brought all those presents.
No key to this place. Just call that one.
There is key for this.
No key to this place. I have mentioned it several times.
Leave the door, tight.
Leave it up.
Who opened the other bigger gate?
They will be even outside here. But before you know,
I'm just very.
and some people will send the people that are standing.
Let them take a picture of us.
You know, was asking me
photographed. Eh? Leave them. Let them be looking for it instead of sitting down. Excuse me, please. Non-accredited photographers, please leave the court. We will start seizing all your cameras now. Sorry. He didn't enter him.
No, he said he didn't want it.
Okay, let me go. Where is the...
One, two. 1, 2. 1, 2. Sound. One, two. 1, 2. Sound test. Sound test. Sound test.
Hello?
No, it's how the oath is going to be.
How?
The oath.
Okay.
No cannot be individual. So we're
We
going
know
to
that. Yeah, collectively, yes. Is it not this one we have?
We have already assumed that it's going to be done in batches.
Congratulations.
Not batches. No, not batches. We're going to admit to everybody. It's late already. Yes.
No problems.
Good afternoon. Please, I would like to notify the conferees that the oath is going to be admitted collectively. So when I say conferees stand, you all stand, each and every one of you, please. or if you don't stand and decide to vote for your NCA, the silk won't be authentic. So.
Venga. Have you gotten the protocols? Eh? Sorry? Come, Papa. Hey, they are always coming. The CJ and
It's here. They will give her the.
Okay.
It's not there. It's
Okay.
here when she sits down. They will give her.
Okay, all right.
The conferees will stand, please. Please hold out your forms. Well, the oath form. We're about to administer the oath. I'm going to count up to 3, after which you recite all the oath form. 1, 2, 3, go.
I, Abdul Karim Kana, Abubakar Kana, upon the rank of Senior Vice of Nigeria, has been duly conferred, declare that I will at all times faithfully serve the interests of the Federal Republic of Nigeria in the capacity of the Senior Vice of Nigeria, and to that end will support and uphold the Constitution of Federal Republic of Nigeria 1999 as amended, that I will, to the best of my ability, assist the courts of justice duly established in the Federal Republic of Nigeria in the performance of their judicial functions, and that I will at all times uphold the dignity of the rank of the Senior Advocate of Nigeria. So help me God.
Congratulations.
Please take your seats. I think it's this one. Here. Is this one? No? So I just. The former Chief Justices of Nigeria, Honorable Justice Mahmoud Mohammed GCON, Honorable Justice Walter Onogen GCON,
Honorable Justice Olukayode Ariwola, GCON, my brother justices of the Supreme Court, serving and retired, President and Honorable Justices of the Court of Appeal, serving and retired, here present, my Lords, Heads of Courts, Honorable Judges of various jurisdictions here present, Your Excellency, the Executive Governor of Borno State, and the Minister of the FCT, Barrister Nyesom Wike, the Honorable Attorney General of the Federation and Minister of Justice, Prince Lateef Fagbemi, Senior Advocate of Nigeria, distinguished members of the National Assembly here present, members of the Inner and Outer Bar, the President of the Nigerian Bar Association, His Royal Highness Honorable Justice Sidi Bagay, Mohammed I, JSC, retired, and other esteemed royal fathers here present, distinguished invited guests, gentlemen of the press, ladies and gentlemen. It is with great pleasure that I welcome you to this session marking the commencement of the 2024-2025 legal year, which also serves as my first official address just a few hours after being sworn in as the Chief Justice of Nigeria. Reflecting on the 2023-2024 legal year, it was a period of intense challenges, notably marked by the judiciary's handling of all petitions arising from the 2023 general elections, and at the Supreme Court with a depleted number of 10 justices. These cases highlighted the judiciary's pivotal role in safeguarding Nigeria's democratic integrity. The judiciary also determined high-profile cases involving constitutional issues, economic crimes, and public interest litigation, while advancing reforms aimed at improving justice delivery. Through collective efforts and divine grace, we overcame these obstacles and upheld the rule of law. As we embark on this new legal year, I am confident that we are well prepared for the challenges ahead and remain committed to enhancing the administration of justice in Nigeria. In keeping with the traditions of the Supreme Court of Nigeria, this auspicious occasion is enriched by the swearing in of members of the Nigerian Bar Association who have excelled in their practice and are now conferred with the coveted rank of Senior Advocate of Nigeria. As we celebrate the successes of the past legal year, we also extend our congratulations to these distinguished legal practitioners who were rigorously assessed by the Legal Practitioners Privileges Committee and found worthy of the prestigious rank of Senior Advocate of Nigeria. However, while this is an occasion for celebration, it is equally important to engage in sober reflection. Although our journey has not been entirely smooth, the challenges we faced have provided us with opportunities to learn and improve. In areas where we have excelled, we will strive to raise the bar. And in those where we have fallen short, we will assess ourselves critically and move forward with renewed determination. That said, the Supreme Court and the entire Nigerian judiciary as a whole have fared well in the past legal year, thanks to the prayers, advice, and support of well-meaning Nigerians. As the new legal year unfolds, we look forward to building a judiciary that will be the pride of Nigerians both at home and abroad. The 2023-2024 legal year, which concluded on Friday, 19 July 2024, was marked by several significant milestones. On Monday, the 26th of February 2024, the Supreme Court made history with the appointment of 11 new justices, marking the first time in recent years that the court reached its full complement. These appointments provided much-needed reinforcement to the 10 justices who had been handling the entire workload of appeals. Shortly after the legal year ended, my predecessor, Honorable Justice Olukayode Ariwola, GCON, retired on Thursday, the 22nd of August 2024, having attained the constitutional retirement age of 70 years. I was subsequently appointed in acting capacity on Friday, 23rd August 2024. In the last legal year, the Supreme Court handled 1,124 cases invoking both its appellate and original jurisdiction. These included 435 civil appeals, 269 civil motions, 219 criminal appeals, 102 criminal motions, 89 criminal appeals, and 10 originating summons. A total of 247 judgments and rulings were delivered, including 74 political cases, 92 civil cases begun by originating summons, and 81 criminal cases. This remarkable success is attributable to the dedication and teamwork of my fellow justices and court staff. The Supreme Court of Nigeria remains one of the busiest in the world, a testament to the upsurge in litigation which has kept our dockets full. Our workload is intense. We work from Monday to Friday, holding daily sittings. Wednesdays are reserved for chamber sitting to consider non-contentious matters, while Fridays are dedicated to delivering judgments and rulings. I am deeply grateful to Almighty God for giving us the strength to accomplish so much. However, I encourage litigants to embrace alternative dispute resolution mechanisms to ease the burden on our courts. The culture of litigating every disagreement and appealing every lost case, no matter how trivial, contributes significantly to the backlog of pending appeals in the Supreme Court and the Court of Appeal. This trajectory is unsustainable for a nation striving for economic development and human capital growth. Educating Nigerians on the benefits of alternate dispute resolution is a collective task for all stakeholders in the justice sector. In this regard, concerted efforts are being made to ensure that the Supreme Court Mediation Center becomes operational to make the desired impact in the new legal year. The Corruption and Financial Crime Cases Trial Monitoring Committee, chaired by Honorable Justice Suleiman Galadima, CFR JSC retired, has been instrumental in expediting the trial of corruption and financial crime cases in the country. Working in collaboration with anti-graft agencies, the committee has facilitated a significant rise in the dispensation of corruption cases. Between the 2nd of January 2024 to 2nd August 2024, the Economic and Financial Crimes Commission, EFCC, with the committee's support, secured 2,387 convictions, while the Independent Corrupt Practices and Other Related Offences Commission, ICPC, filed 54 cases and secured 11 convictions. While holding the judiciary accountable where we fall short, we should also commend the courts in deserving cases for their commendable performance in handling these cases. This is a new dawn and a new era in the Nigerian judiciary. I want to assure my fellow Nigerian citizens that we are committed to working more diligently to improve public perception of the Nigerian judiciary. Over the years, various factors have contributed to the negative image of the judiciary. However, we are determined to change this narrative and make the judiciary a source of pride for all Nigerians. When the legal compass of a nation falters, everything suffers, including public and international perception. The attitude of some of us in the justice sector is sometimes less than salutary, and that has, to a large extent, contributed to the current image deficit of the country's legal system. Forum shopping by some of our legal practitioners is rampant. It is such acts that often give rise to the emergence of conflicting orders by courts of coordinate jurisdiction. I would like to state clearly that henceforth there will be consequences for any act of indiscretion that could bring the judiciary to disrepute. We have rules and ethics guiding the practice of our noble profession, and we must work assiduously to abide by them and always do what is right in the eyes of the law. Under my leadership, the judiciary will adhere to the principles of honesty, transparency, and integrity. I call upon all judicial officers and members of the bar to join me in achieving this goal. The independence of the judiciary is always a topical issue. Let me categorically state that the Nigerian judiciary is independent in conducting its affairs and rendering decisions without interference. At the Supreme Court, for instance, our judgments are free from external influence. While it is essential for the judiciary as a third arm of government to maintain good working relationships with the executive and legislative branches, this should not be misconstrued as subservience. The issue of the salaries of judicial officers, which has for a very long time occupied the front burner of national discourse, has now been addressed through the concerted efforts of many stakeholders, culminating in the unanimous passage of the Judicial Office Holders' Salaries and Allowances Bill by the 10th National Assembly. His Excellency, the President and Commander-in-Chief of the Armed Forces, Senator Bola Ahmed Tinubu, GCFR, gave his assent to the bill on Tuesday, 13th August 2024. With this significant development, we now have in place the Judicial Office Holders Salaries and Allowances, etc. Act 2024. This significant milestone has empowered every judicial officer in Nigeria to make more meaningful contributions to national development. Nevertheless, it is necessary to continuously review the welfare package to meet changing economic trends and address pressing infrastructural needs of our courts. While current judicial officers may benefit from some of the reforms, those who are transitioning out of service or have already retired are often left without adequate support, especially in terms of health care. The lack of access to proper medical care has had a profound effect on both serving and retired judicial officers, many of whom face severe health challenges with limited assistance. This issue is equally concerning for those who are nearing retirement as they confront the reality of insufficient healthcare provisions once they leave active service. The rising number of deaths among serving judges and justices, as well as retired justices and judges soon after retirement, underscores the gravity of this situation. Addressing these gaps by ensuring access to comprehensive health care and improved infrastructure for both serving and retiring judicial officers and staff is crucial to preserving the dignity and well-being of those who have dedicated their lives to serving the judiciary. It is imperative for the judiciary to uphold the tenets of the Constitution, which remains the supreme law of the land. The rule of law, as the cornerstone of every functional democracy worldwide, should be strictly adhered to in all our undertakings. We must emphasize the importance of this principle to citizens at all levels, encouraging them to actively walk the path of legality and justice. The rights of every Nigerian must be vigilantly safeguarded against oppression and impunity, utilizing the full array of legal instruments at our disposal. Furthermore, obedience to court orders is non-negotiable. No individual or institution, irrespective of their standing, will be permitted to treat the judgments of our courts with levity or disregard. The judiciary stands resolute in ensuring that the sanctity of our legal decisions is upheld. All hands must be on deck in fostering an unwavering commitment to the full enthronement of the rule of law. Disobedience to court orders or non-compliance with judicial directives is a direct affront to democracy and an invitation to anarchy. As such, it is critical that we respect and observe all the features of an enduring democracy, for in doing so, we maintain the delicate balance that sustains our society. Let us therefore work collectively and tirelessly to ensure that Nigeria continues to abide by the rule of law, upholds the best democratic practices, and remains vigilant in the protection of her citizens' rights. No doubt, the effective administration of justice has always been a pivotal concern in our legal landscape, and recent efforts to modernize the system are crucial in addressing its persistent challenges. Central to these efforts is the enactment of the Administration of Criminal Justice Act, ACJA of 2015, which has been domesticated in various states in Nigeria. However, despite its potential to modernize the administration of justice in the criminal justice sector, Key provisions remain underutilized and its full impact has yet to be realized. One major area of concern is the recurrent practice of arraigning suspects in court without proper preliminary investigations. In many cases, efforts to gather evidence are only initiated after trial has begun. This backward approach to criminal prosecution significantly delays the process and undermines the delivery of justice. It is unacceptable that in 2024, we continue to see such practices which contribute to the overwhelming backlog of cases in our courts and ultimately erode public confidence in the justice system. The ACJA, however, provides solutions to some of these problems if fully implemented. For instance, Section 15, subsection 4, mandates that a suspect's extrajudicial statement must be made in the presence of a legal practitioner of the suspect's choice, or where the suspect is unable to secure one, in the presence of an officer of the Legal Aid Council. Additionally, the Act requires that the entire process be video recorded. These provisions are designed to ensure transparency and fairness in the treatment of suspects, reducing the risk of coerced confessions or procedural abuses. Unfortunately, many law enforcement agencies and prosecutorial bodies have not yet embraced these critical safeguards. The failure to adapt these measures exacerbates delays and inefficiencies, resulting in prolonged detentions and frequent adjournments due to inadequate evidence. Full compliance with these provisions of the ACJA would not only streamline the investigative and prosecutorial process, but also enhance the credibility and integrity of the criminal justice system. The effective implementation of the ACJA and ACJLs in the states must be prioritized. Law enforcement agencies, prosecutors, and judicial officers need to be properly trained and equipped to adhere to the requirements of the Act. In addition, mechanisms for accountability must be established to ensure compliance with these provisions. Beyond the ACJA, other critical aspects of our criminal justice system, including reforms in policing, the legal process, and the protection of individual rights, must be pursued with urgency and determination. These reforms are essential to creating a more efficient, transparent, and just criminal justice system that reflects the needs of a modern society. It is my intention to strengthen our processes, provide speedy and qualitative administration of justice, reinforce our structures from the Supreme Court to other courts of record, and reduce corruption to the barest minimum in the system. The Code of Conduct for judicial officers will be strictly enforced. Similarly, the requisite ethical standards will be expected of the bar. Staff of the judiciary will also be expected to strictly comply with the Code of Conduct applicable to them. I must reiterate that the task of cleaning the audience table is a collective one, and my commitment to it is unwavering. I assure you that I will pursue it vigorously. The Supreme Court Rules 2024, which came into effect on 1st August 2024, introduced innovative provisions to enhance the efficiency of justice delivery. For instance, the rules provide for an automatic extension of time to file certain processes in the first instance for the same period without penalty, and in the second instance with the payment of a penalty in default. Thereafter, no further extension of time will be allowed except in an appeal against the death penalty. This innovation eliminates applications for extension of time to file processes which hitherto unnecessarily clog the court's docket. The period provided for the filing and exchange of briefs has been reduced, while greater responsibility is placed on legal practitioners in certain regards to ensure the speedy hearing of appeals. A notice of non-contention must be filed where a party does not intend to contest the grant of an application. Where service of a process is effected on a legal practitioner who has ceased to appear for a party, failure to inform the court expeditiously will be deemed an act of professional misconduct. Furthermore, where costs have been awarded against counsel personally as a result of abuse of court process, he shall file a certificate of compliance within 90 days of the order, failing which he will not have the right of audience in any superior court of record until compliance. Where costs are awarded by the lower court, they must be paid into an escrow account in a commercial bank in the name of the chief registrar. A certificate of compliance duly verified by the registrar of the court below must be compiled along with the record of appeal. Failure to comply shall be deemed as failure to comply with the conditions of appeal with the necessary consequences thereto. We have also made significant strides in modernizing our operations through technological innovations. We have now successfully automated the enrollment unit of the Supreme Court of Nigeria in March 2024. All lawyers called to the Nigerian Bar can now enroll online. Prior to the automation of the enrollment exercise, physical presence of all lawyers at the Supreme Court of Nigeria for enrollment was a recurrent feature. However, with the new development, the enrollment exercise has now become seamless and less cumbersome, as it can be done with ease from the comfort of the applicant's respective homes. My lords, distinguished invited guests, ladies and gentlemen, I wish to reiterate that the rank of Senior Advocate of Nigeria comes with immense prestige and greater responsibilities. Those conferred with the rank automatically become members of the inner bar and revered apostles of the Temple of Justice. It is an honor no conferee can afford to take for granted. The Legal Practitioners Privileges Committee painstakingly screened and holistically assessed all the documents submitted by the applicants before arriving at its decision. Even though we know that there is no human system that is infallible, at least concerning the efforts put in place by the committee, I can say with all sense of responsibility that they have done a good job. The 2022 guidelines for the conferment of the rank of Senior Advocates of Nigeria require very high standards of merit from all the applicants vying for the award. Every requirement contained in the guidelines was strictly observed before arriving at the final list. There were 127 applicants for the 2024 exercise. Out of this number, 114 are legal practitioners and 13 are academics. The total number of qualified applicants after the preliminary screening was 98. After conducting the specified screening and filtration exercises, which include a number of appearances in superior courts, recommendations by Honorable Justice of the Supreme Court and Honorable Judges of Superior Courts, Chambers inspection, approval and eligibility and integrity of the candidates from the Nigerian Bar Association, Body of Senior Advocates of Nigeria, and of course the general public among others, the LPPC approved 87 successful candidates who by all standards can be regarded as eminently deserving of the rank of Senior Advocates of Nigeria. Out of this number, 86 are advocates, while one is from the academia. This is indeed a great feat. On behalf of my learned brother justices of the Supreme Court and members of the Legal Practitioners Privileges Committee, I congratulate the 87 successful senior advocates that have just been sworn in. Your success did not come on a platter of gold. You have worked for it. You deserve every privilege, honor, and pride that comes with it. As senior advocates of Nigeria, you carry on your shoulders a lot of responsibilities. From this moment, your behavior and general conduct will now be publicly scrutinized by all those who come in contact with you. Watch your utterances, watch your actions, and watch your company, as you now have an even higher responsibility to assist the court in attaining justice, equity, and fairness. You must display enormous integrity, self-discipline, leadership, and high standards of advocacy. The conferment of the rank on you today authorizes you to use the letters SAN as a lifetime appellation after your names. Similarly, it has conferred on you the uncommon privilege of wearing the silk gown and full-bottomed wig. In addition, you now have the enviable privilege of sitting at the inner bar of our courtrooms across the country and having your cases mentioned first in all courts. However, you are reminded that the rank of Senior Advocate of Nigeria is a privilege and not a right, conferred after due deliberations by the Legal Practitioners Privileges Committee. It is a privilege that can be withdrawn if it is abused. As holders of the esteemed rank, a higher level of integrity, ethics and accountability is expected of you. The young lawyers equally need your mentoring and guidance, while the court needs your erudition, advocacy, and positive contribution to effective justice delivery. It is opposite at this stage to note that the review of the requirements of the rank of Senior Advocate of Nigeria will be a continuous process in order to ensure that the highest standards are maintained. The docket of the Supreme Court is unnecessarily clogged by legal practitioners seeking to attain the rank by making up the required number of judgments from the court, whereas many of the appeals do not contribute to our jurisprudence. I also seize this opportunity to comment on the mode of dressing by some of our lawyers, especially the younger ones, which does not reflect the honor and dignity of the legal profession. I must unequivocally state that any lawyer who does not adhere to the prescribed dress code for legal practitioners will not be permitted to appear in court. Such disregard for professional decorum undermines the prestige and global respect that the legal profession commands. I call upon the leadership of the bar to take proactive measures to properly guide and mentor the young lawyers. They must be continuously educated on the essential standards of our profession, especially regarding dress code and ethical conduct. It is equally important to remunerate your juniors appropriately, as fair compensation is crucial to nurturing talent and ensuring job satisfaction. This responsibility is the first task I'm assigning to both the new Senior Advocates of Nigeria and the leadership of the Nigerian Bar Association, which incidentally is assuming its role at the same time as I take up this mantle. I am confident that together we will succeed in restoring the dignity and reputation of both the judiciary and the legal profession in our country. The Nigerian Bar Association has consistently demonstrated its commitment to the pursuit of justice in our nation. The leadership of the association has fostered a strong and mutually beneficial relationship with the bench, and this is highly commendable. On this occasion, I wish to congratulate the immediate past executive for the numerous milestones achieved during their tenure. One notable achievement is the seamless deployment of modern technology to register all participating lawyers across the country for the 2024 Annual General Conference. Following the successful online election in July 2024, which resulted in the election of Mazi Afam Osigwe, Senior Advocate of Nigeria, as the 32nd president of the association. This process has once again provided the Nigerian society with a valuable lesson. We are capable of effectively utilizing technology to elect our leaders with transparency and efficiency. I was particularly impressed by the turnout and active participation of legal practitioners at the recently concluded 64th National NBA Annual General Conference held in Lagos in August 2024. The remarkable assembly of such a large number of lawyers under one roof is indeed a noteworthy accomplishment. I extend my heartfelt congratulations to the immediate past NBA president, Mr. Yakubu Mekiao, Senior Advocate of Nigeria, and his team. The quality of resource persons and the thought-provoking papers presented at the conference centered on the theme, pressing forward a national posture for rebuilding Nigeria, have undoubtedly reignited our collective resolve to build a prosperous society. I also extend my warm congratulations to the newly elected president of the NBA, Mazi Afam Osigwe, Senior Advocate of Nigeria, and wish him a successful and impactful tenure. We look forward to continued cooperation and collaboration, building upon the solid foundation laid by the immediate past executive. Finally, I wish to express my sincere gratitude to everyone present today for attending this special session to mark the commencement of our new legal year. I deeply appreciate your presence, despite your undoubtedly demanding schedules and the change in time for this ceremony. I would like to extend my sincere appreciation to the Honorable Minister of Justice and Attorney General of the Federation, Prince Lateef Fagbemi, Senior Advocate of Nigeria, the Chairman of the Body of Senior Advocates of Nigeria, Professor Alfred Bandele Kasumu, Senior Advocate of Nigeria, the President of the Nigerian Bar Association, Mazi Afam Osigwe, Senior Advocate of Nigeria, and the spokesperson for the newly conferred Senior Advocate of Nigeria, Mr. Lateef Olasende Karim, Senior Advocate of Nigeria, for accepting to deliver remarks at this gathering. Thank you all for your invaluable time and presence. Thank you. Yes, but let me announce the next. Yes. I will now call on the Honorable Attorney General and Minister of Justice, Ms. Prince Lateef Olasunkami Fagbemi, Senior Advocate of Nigeria, for his remarks.
Okay. You can lift it up if you like. My noble Lord, the Honorable the Chief Justice of Nigeria, may I crave your indulgence to allow me leverage on the existing protocol you have so admirably rolled out a while ago. And I continue by saying that it is an honor for me to be invited to address this esteemed legal assembly today at the dawn of a new legal year. It is a time to reflect on the vital role of the Supreme Court in our national life and to reaffirm our commitment to the rule of law as a profession. Today signposts a momentous occasion for our judiciary and the entire nation as we gather in these hallowed chambers of the Apex Court to witness the third of ceremony consisting of the formal flag-off of 2024-2025 legal year of the Supreme Court of Nigeria, the first sitting of my noble Lord as the substantive Chief Justice of Nigeria to preside over the conferment of the prestigious rank of Senior Advocate of Nigeria on 87 deserving legal practitioners. We thank God for the gift of a new Honorable Chief Justice of Nigeria, my noble Lord, Honorable Justice Kudirat Mutomori Olatokunbo Kekereekun, CFR, at least for now, on your Lordship's appointment as the substantive 19th Indigenous Chief Justice of Nigeria and 23rd Chief Justice of Nigeria in general. And with joy immeasurable, I am already looking forward to my Lord's rollout of impactful initiative that will strengthen not just the Supreme Court, but the entire judicial and legal system in Nigeria. I am confident that under the leadership of our esteemed Chief Justice of Nigeria, the Supreme Court will unlock new vistas of investment in public trust and in shaping public policy, as well as consolidating our legal jurisprudence. It is also gratifying that one of the most recent initiatives of this court towards enhancing efficient appellate justice delivery is the Supreme Court Rules 2024, prepared by a Rules Committee, the Rules Committee headed by my Lord, the current Chief Justice of Nigeria. The new rule, with all the well-received and promising innovations introduced therein, will now be seamlessly rolled out directly for use by practitioners in this court as the new legal year kicks off. I can only beseech my learned colleagues to quickly internalize and embrace the rules so that its many well-thought-out benefits can begin to manifest in earnest in the justice delivery at the Supreme Court. I am most delighted that my Lord has hit the ground running by identifying some core areas requiring attention, including deployment of technology in the administration of justice, zero tolerance for corruption and all forms of abuses, such as vexed phenomenon of frivolous ex parte orders, media trial by lawyers in clear breach of the principles of sub judice and rules of professional conduct, not discounting possible reforms for insulating the Supreme Court from pre-election matters, and so on. I share in your Lordship's vision and do pledge my unflinching support. I strongly commend the Honorable the Supreme Court, both serving and retired, for your Lordship's commitment and sacrifice, as illustrated in illuminating rulings and judgments that were delivered in the year or period 2023-2024 legal year. Those decisions have significantly impacted on socio-political and public policy of the nation. The recent landmark judgment of 11th of July 2024 on financial autonomy for local governments is still resonating in respective reactions among stakeholders. This judgment, which has been greeted with huge sighs of relief, will certainly enhance socio-economic development and reduce insecurity at the local level, which is the base of the pyramid. Distinguished ladies and gentlemen, it is undoubted that the Supreme Court has the sacred mandate of acting as the last person in defense of our Constitution. This is why the court sits in the pinnacle of our judicial system, playing the pivotal role of upholding the rule of law, advancing and protecting democratic governance, and offering the unique service as the core regulator of Nigeria's judicial and legal systems. As the Attorney General and the Chief Law Officer of the Federation, I am not oblivious of the immense responsibility that rests upon the shoulders of your Lordships. The Supreme Court has remained steadfast in its commitment to upholding the principles and policies outlined in the 1999 Constitution as altered. Your decisions have helped our nation's trajectory, providing guidance and clarity in terms of uncertainty. In realization of the fact that your Lordship's decisions have direct and profound impact on the lives of millions of Nigerians, such decisions must, therefore, be grounded in law and informed by the values and visions of our nation. Let me reiterate the profound pronouncement of His Excellency President Bola Ahmed Tinubu, GCFR, at the epoch-making event of the swearing-in of our fresh-from-the-oven Honorable Chief Justice of Nigeria at about 11:21 a.m. today, of his commitment to continue to preserve the sanctity of the judiciary. The President also promised that the independence, autonomy, welfare, and development of the judiciary will continue to receive priority attention under the current administration. The President is a man who walks his talk. I want to assure the Justice constituency that this administration will live up to its pledge to accord obedient respect for judicial decisions and rule of law, in realization of the fact that sound and just judicial pronouncements are enablers of the critical factors that drive socio-economic development. We will, therefore, continue to take proactive steps to avoid undue exposure of government to legal liabilities. The nobility of our legal profession demands unwavering commitment to the principles of fairness, equity, and pursuit of excellence in values that we hold dear. Thus, the conferment of the coveted rank of Senior Advocates of Nigeria is a fitting acknowledgement of the outstanding contributions of learned colleagues to the profession and to the nation. It is a testament to hard work, dedication, and commitment to the highest standards of legal practice. Let me now progress to the second ground of our gathering here today, which is to felicitate with the 87 of our illustrious colleagues who have just been adorned with the regalia of learned silk. It is indeed a high sense of nostalgia and elation that I congratulate you all on this worthy professional attainment. The conferment of the rank of Senior Advocate of Nigeria is not just a recognition of excellence for those conferred, but it is also a motivation for those aspiring to be admitted into the inner bar. I also wish to commend the Legal Practitioners Privileges Committee, otherwise known as LPPC, and all stakeholders who have contributed their quota to the emergence of the new silks for the human job you are doing over the years to reward excellence, ethics, and perseverance, as well as sustaining standards in the legal profession. I joined the LPPC, Nigerian Bar Association, and the Body of Senior Advocates of Nigeria. I enjoined them not to relent in maintaining and enforcing a continuous culture of excellence, legal ethics, scholarship, and professionalism in the practice of law in Nigeria. To the new silk, I know you have prepared to have events to mark this occasion. I will not disturb you, but it is important that I say this, that I warmly welcome you to the inner bar, and that to say that it is indeed a remarkable privilege to be chosen and decorated with honor amongst your colleagues. The name of the LPP, as the name of the LPPC implies, the conferment of the rank of Senior Advocate of Nigeria is a privilege for the deserving only. Every visionary professional strives to attain the apex of such profession. Expectedly, the rank is being conferred on worthy advocates as a prestigious honor in recognition of their excellence in advocacy and leadership role in the field of law or legal practice. Your new and enviable status demands that you must be honest and maintain professional standards at all times within and outside the courtroom towards the judex, your colleagues, clients, and the public in general. You must maintain very high standard of professional conduct in the discharge of your duties. Being a privilege also means that it can be lost or taken away, and it is worthy of note that under the new rules, once a name is struck off, there is no provision for restoration of the name to the roll. Therefore, you must continue to maintain the standards and qualities for which you are considered worthy of the rank ab initio. I wish to remind you that your new status comes with its peculiar privileges, benefits, challenges, and responsibilities. Your preoccupation should not just be limited to the privileges and pecuniary benefits associated with the rank. You are required to advance the cause of justice, rule of law, promotion of the image or rating of the judiciary and legal profession as worthy ambassadors. You should always be willing and ready to exhibit exceptional understanding and knowledge of the law, contribute to the legal education. The development of the legal profession rests on your shoulders. You must therefore advocate for technological and modern innovations that will bring the practice of law in Nigeria in line with global standards of global practices. My lords, distinguished ladies and gentlemen, as you are being welcomed to the inner bar, it is important to remind you that you are the second set of senior advocates of Nigeria to be elevated under the provisions of 2022 guidelines for the conferment of the rank of senior advocates of Nigeria. Like I said earlier, I'm sorry if I repeat myself, one of the highlights of the new guidelines is that unlike the 2018 guidelines, which contained provisions for discipline of erring holders of the rank and for the restoration of the rank after 3 years of withdrawal upon fulfillment of certain conditions, the 2022 guidelines is very strict, makes no provision for the restoration of the rank after withdrawal. In other words, but I have said that before, and I say one of the areas you must avoid, like the plague, is the unwholesome practice of engaging in media trial of cases pending before the courts. It is unprofessional for a legal practitioner and a senior advocate of Nigeria to be seen engaging in the analysis of cases pending before the court. We have seen cases where legal practitioners appear at television or radio stations discussing pending matters. We have also seen lawyers after court sitting discussing what transpired in the proceedings. You must resist the urge to engage in such practice. You must also reject the invitation by the media houses inviting you to analyze or discuss pending matters. The doctrine of sub judice enjoins lawyers and even members of the public to refrain from commenting and discussing live issues or cases. You should not be seen breaching this doctrine. However, where judgment has been delivered in a given matter, lawyers and the public are free to analyze and discuss the decisions without impugning the integrity of the judicial personnel involved or stalking the professional competence of counsel involved in such matters. As leaders of the bar, you should resist the urge to engage in such unbecoming conduct or creating unwholesome content for the social media. It is therefore your abiding duty to project, promote, and ensure the integrity and independence of the judiciary at all times. Every worthy professional in the world seeks the good and progress of their profession. We, the members of the legal profession, cannot afford to ignore our nobility by publicly denigrating or ridiculing the judiciary and, by extension, the profession by our actions and utterances. We must only do so we can only do so to our own peril. I'm so sorry, my lord.
Sorry.
I apologize. We can only do so to our own peril. I am not advocating that we should condone or tolerate shortcomings or any form of misconduct, but you must follow accepted procedure and channels to avoid collateral and collective damage. Your coming on board at such a challenging time as this requires that you passionately seek to enhance or achieve paradigm shift from the status quo by avoiding infamous conduct that will further damage public perception about our court system, being mindful of the fact that the importance of public confidence in the judiciary cannot be overemphasized. Having been elevated to the inner bar, you are now regarded as part of the leadership in the legal profession. However, you are still amenable to the mentorship of the very senior elders at the inner bar. Law is a dynamic profession. We learn every day, and the seniors are there to play the role of mentors. You are therefore in a unique position of still being mentored by the elders in the inner bar, while at the same time acting as mentors to the younger ones at the bar. You must therefore be good mentors by showing good examples in and outside the courtroom. I believe that the one-day induction course organized by the Body of Senior Advocates of Nigeria, otherwise known as BOSAN, here in Abuja last week, will go a long way in assisting to appreciate the task ahead and how to go about them. As legal practitioners, we act as the conscience and gatekeepers of the legal profession. Legal practitioners must refrain from abusing their privileged position as the link between the litigant and the judiciary. It is not the exclusive prerogative of litigants to determine which cases get filed in court or which judgment goes on appeal. We must be firm in sieving these cases in order to avoid filing of frivolous cases or appeals, which clog the already congested court dockets. In this wise, I wish to recommend to you the wise admonition of His Lordship Dawunsi Olugbemi Koka, JSC of blessed memory, in the case of Adewumi versus Plastic Nigeria Limited, citation provided, where he said, quote, every lawyer upon his own responsibility must decide what case he will bring into court for plaintiff and what case he will contest in court for defendant. He has the responsibility for advising as to questionable transactions, for bringing questionable suits, and for arguing questionable defenses. He cannot escape it by arguing as an excuse that he is only following his client's instruction, unquote. On this note, accept my congratulations on your ascendancy to the zenith of your professional career as advocates, and this attainment should not be a mere badge or right for bragging and show off. You must remain true to the calling of being advocates in the temple of justice, which was what earned you the conferment of this prestigious rank in the first instance. My noble Lord, distinguished ladies and gentlemen, today's occasion also presents an opportunity for my office to give an update on our various interventions aimed at achieving a justice system that works in the interest of Nigeria. On my inauguration as Attorney General and Minister of Justice, I did state that I recognize the need for sustainable reform of our justice sector. Indeed, every aspect of our justice system requires rethinking in fundamental ways. I also did stress that while I understand the need for far-reaching reforms, the reforms of our justice sector will not be an event, but changes must be accelerated to keep up with the expectations of Nigerians for an efficient and effective justice system. I also said that our approach to reform will not be dogmatic. It will open to all ideas and move us closer to the justice system that we all desire. Much of the interventions that we are undertaking, therefore, are outcomes of a consultative and inclusive process. We make no pretense about knowing it all. We are open to constructive engagement and criticisms that will yield results. The starting place of our justice sector reform intervention has been the Federal Ministry of Justice. We recognize that charity must necessarily begin at home. We have, over the last year, taken steps to ensure that our work environment is conducive and enabling for all those who work in the Federal Ministry of Justice. We firmly believe that the place we work is as important as the work we do. Aside from improving facilities in the ministry, we also continue to positively take steps that improve the conditions of service of all those who work in the ministry. No less important is the need to ensure that all departments, agencies, and institutions under the Federal Ministry of Justice perform optimally. In line with the directive of Mr. President that every ministry, department, and agency should justify its existence, deliberate efforts will be made over the next month to review their activities and level of service delivery to Nigerians. We are taking steps to implement the far-reaching outcomes of the National Judicial Sector Summit, which was held during the last legal year. The proposals for institutional, legislative, and constitutional reforms across the justice sector have been identified, and the consequential bills have been drafted for consideration of the Federal Executive Council and subsequently to be presented to the National Assembly. I look forward to the continued productive engagement and collaboration with the judiciary and the Nigerian Bar Association to ensure that these proposals are speedily implemented. I can now announce that all the issues responsible for the lack of progress on the Legal Practitioners Amendment Bill have now been resolved. I am grateful to the understanding and support shown by the Nigerian Bar Association and the body of benchers under the leadership of Asiwaju Gboyega Awomolo, SAN, on this long-delayed bill. My office will now proceed quickly to ensure its enactment into law. During this legal year, a major component of our deliverables will be the focus of our criminal justice system. Specifically, my office will renew efforts in bringing together federal and state government institutions whose mandate directly relates to criminal justice administration. The increasing number of persons in our custodian centers is simply not acceptable. Specifically, we need to rethink our approach to discongesting our custodian centers nationwide. The current situation, in my considered view, is no longer simply an access to justice, but one with serious implications on national security. I anticipate, my Lord, the Honorable Chief Justice of Nigeria's leadership on this matter. We need a fresh approach that places additional responsibilities on the judiciary. On my part, I commit to providing leadership to the body of Attorneys General to ensure the attainment of tangible results. President Bola Ahmed Tinubu, GCFR, is aware of the concerns about the status of our laws and the urgent need to review the laws of the Federation. It is obvious that our laws need to respond to the current development, not only nationally but also globally. Our desire to make rapid progress in all aspects of our socio-economic and indeed political life requires that we have enabling and empowering legislation. It is for this reason that the federal government has constituted a working group on the review of the laws of the Federation. The essential mandate of the working group is simply to review laws and propose laws that will support the development of all aspects of our national life. We are determined to deliver a revised laws of the Federation by the commencement of 2025 legal year. The working group is under the able leadership of, chairmanship of Olawale Fapounda, Senior Advocate of Nigeria, and Senior Advocate of Nigeria. On behalf of Mr. President, I want to thank the chairman and members of this working group for accepting to serve in this role. I should restate that reforms of the justice sector cannot be exclusive preserve of the Office of Attorney General of the Federation. I once again invite all justice sector stakeholders, including those in the private sector, to take more than a passing interest in these interventions. It is important that all of us, especially those of us who are affected daily by the inherent limitations in the sector, do more than social media criticisms. It is time for us to be part of the solutions. There is no scarcity of literature on the challenges facing the sector. We need to respond to the dearth of solution. In closing, my Lord, the Honorable, the Chief Justice, distinguished invitees, distinguished ladies and gentlemen, Your Excellencies, as we embark on this new legal year, I urge all of us to renew our commitment, dedication, and initiatives aimed at promoting democratic tenets, including the administration of justice, rule of law, and access to justice for all, in order to engender a more just, prosperous society. The Lordship should neither waver nor falter in the commitment to the principles of justice, especially the rule of law. I want to thank you for listening to me. Now, good.
Thank you, the Honorable Attorney General and Minister of Justice. I will now call on Chief O. Opoku, Senior Advocate of Nigeria, to deliver the remarks on behalf of the body of Senior Advocates of Nigeria.
Thank you. Thank you, my Lord. Thank you, my Lord. Please permit me to stand on the protocol already established by His Lordship. And I take this opportunity to apologize that I came in rather late. I apologize, my Lord. Today we are gathered in this special session of the Supreme Court to witness and attest to the official ceremony of the opening of the 2024 to 2025 legal year of the Supreme Court, and to admit to the inner bar the record number of distinguished legal practitioners adjudged by the Privileges Committee of the legal profession to be deserving of the honor of being admitted to inner bar in this temple of justice. This morning, His Lordship, Honorable Justice Kudirat Motomori, please forgive me if I pronounce it like an Urubomans, Olatokumbo Kekereegu, was sworn in as the substantive Chief Justice of Nigeria. And here we are on this same day. This one is the Honorable Chief Justice of Nigeria is presiding here over the special session of the Supreme Court and performing the first official ceremony of declaring open the 2024-25 legal year of the Supreme Court and admitting to the inner bar this record number of the members of the outer bar. On behalf of the body of senior advocates of Nigeria, BOSA, I congratulate your Lordship, the Chief Justice of Nigeria, who, on this glorious day of your assumption of office, of the substantive office of the Chief Justice of Nigeria, without delay, proceeded with the ceremony we are all witnessing now in the nation's highest court of law. These are monumental and eventful events which our courts have never before witnessed. May His Lordship's tenure as Chief Justice of Nigeria be a blessing to the judiciary, the Nigerian legal profession, and our dear and only country, Nigeria, and its people. To our new colleagues joining the inner bar today, you must count yourself blessed and fortunate to be the first fruit of the historic day of being admitted to the inner bar at the very first official ceremony of His Lordship official duty as the Chief Justice of Nigeria. On behalf of the body of senior advocates and our leader, Chief A.B. Kasumu, SAN, I congratulate each of our new members for safely and successfully negotiating the steep ladder through the Privileges Committee screening process. You must not regard your success in the screening process as the final step of the long road in your professional life. It is just the beginning of the journey. On occasions of this special session of the Supreme Court, when the court is open to lawyers, non-lawyers, legislators from federal and state, and members of the Fifth Estate of the Rim to attend, listen to, and hear words from the judiciary, the Honorable Attorney General, from whom we've just heard, for the executive arm of government, the body of senior advocates, and the Nigerian Bar Association. The words and suggestions made at such occasion may assist in the action plan of the government for the building and or formulation of policies for the nation and the executive acts of government. To our new members of the inner bar, I have said your elevation to the inner bar today is just the beginning of a lifelong journey. The oath you take today will impose on you certain duties and responsibilities in addition to the duties of a legal practitioner you have always known. As a senior advocate, you are a leader in the profession. This status imposes on you the duty to go forth and serve our nation in justice. The implication of this duty is that in all aspects of life from today, you shall be required to perform your duties and regulate your life in such a way as to ensure that your conduct as a bar leader and a lawyer will not adversely affect the honor, dignity of the legal profession, or in any way allow you to engage in anything that smacks of indiscipline in the administration of justice in the country. In this regard, you have to learn to respect the rules and the ethics of the profession at a level higher than you have done in the past. You must now be seen, and your conduct and performance must now be seen to be transparent, honest, either in the conduct of cases before the courts or in the advice you give to your clients. You have a duty to be loyal to the Nigerian Bar Association, the organized voice of the legal profession in Nigeria, the body of senior advocates of Nigeria. You must not look down upon the NBA, our officers, and your colleagues of the outer bar. Everything you do as a senior advocate must be won decently and appropriately in the manner expected of a gentleman in black. You know all these things. I'm only reminding you of them because some of our colleagues in recent past do not seem to appreciate the need to do what I'm asking you to do. Now that you are a senior advocate of Nigeria, I'd like to remind you again that very disruptive proposals had emanated from members of the inner bar. The first is the attempt by members of the inner bar in the Federal Capital Territory to establish themselves and to divide the single and united body of senior advocates of Nigeria into branch or segments for no justifiable reason and without authorization by the incorporated body of senior advocates of Nigeria. I do not intend to say anything more on this because our senior and leader, Professor A.B. Kasumu, has said it all. Mine is just to affirm the position of BOSAM as stated clearly by Professor A.B. Kasumu in the statement he issued on the 6th of May, 2024. BOSAM is one and the only body for senior advocates of Nigeria. The body has neither branches nor sectors in its constitution. The duty of every senior advocate is to back the stand of BOSAM by our senior and leader. Do not be misled. Therefore, do not be misled, therefore, into following a wrong step which BOSAM has already deprecated. Multiplicity of institutions and bodies is not the way to go for the advancement of the practice of law, as our founding fathers have stated. Let no one, no matter how connected or influential, rock the boat of the legal profession in Nigeria. Another attempt by some group of lawyers is their suggestion that a new regulatory body called Law Society of Nigeria be created for the legal profession. The suggestion is said to have been modeled on the system in England and Wales, the United Kingdom. As the matter is in court, I will say nothing further on it. Only time will tell. It is enough to say that Nigeria is not United Kingdom. An act which may constitute nuisance in Ikoyi may not be accepted as nuisance in the old Ajegunle in Lagos. The challenge of the profession, as you can see, appear to be due to the indiscipline, due to the nature and circumstance peculiar to Nigeria. What we can do to strengthen the legal profession is to strengthen the rules of professional ethics and the rules and the manner required of a gentleman, which we are. Still, on this line of indiscipline, a clear example was shown recently by the Council of Legal Education, headed by an eminent senior advocate of Nigeria, Emeka Ngigi, who rolled up sanctions against faculties of law in some tertiary institutions. For some time now, our training program for admitting people to the legal profession has been put under stress by act of indiscipline by some faculties of law in our tertiary institutions. The result is that whatever expansion program the Council of Education had, it cannot it cannot afford or provide the necessary staff and facility to admit all students in one stretch. This has led to the problem of alleged law graduates sitting at home for years without getting admission to law school. This has further aggravated this has been further aggravated by the Nigerian factor that seeks to create priority for those connected with influential people, with the influence peddlers. In the present statement, the Council of Legal Education now sanctioned and barred from entering the law school for 5 years or so graduates of several universities in our country whose faculties of law admitted and graduated law students without being accredited by the Council of Legal Education. I dare to say that such indiscipline has not been witnessed in the accounting profession or in the medical profession. Law graduates of several universities whose faculties of law admitted and graduated students without having been accredited by the Council of Education have been barred and or sanctioned from entering the law school. Council discovered that a university that has accreditation for 50 students has in fact admitted 1,000 students to the Faculty of Law. This is a total violation of the facts of the accreditation approved for such university. The council discovered that a university said that one. Yes, I think I've made my point on that one. Now, all this demonstrates the indiscipline that has pervaded many tertiary institutions in the country. Boson congratulates the Council of Legal Education for insisting on the discipline of the system and sanctioning violators. Nigeria will be a better place if all will learn from the experience of the Council of Legal Education. Discipline is the watchword unless our society embraces the principle of adhering to discipline. The development and improvement of life and property of our citizens in our country will continue to elude us. And so, to our new members, we say once again that discipline is the key. So, our Chief Justice, we wish to draw your Lordship's attention to the fact that a booklet titled Supreme Court Rules is being sold in some parts of the country. I have a copy printed from the internet, so it can be presumed that the booklet is available to the whole world. The source of the book is unknown, and the booklet does not appear to contain the date of commencement of those rules. In these days of fake news, fake judgment of all kinds, one can be easily misled to believe that the new booklet is the authentic and official copy of the rules of the Supreme Court. I personally doubt this as to The authenticity, as to the authenticity, I doubt the authenticity of the book, of the booklet, in view of the patent typographical error in it. My Lord, if the book is not the authentic officially issued by the Supreme Court, then kindly clarify for the benefit of the bar and the bench the position of the book. If the position of the book now circulating around, I have described same. I've mentioned the same already. The Supreme, if it is not an authentic copy, then it should be, matter should be looked into. We plead with your Lordship that members of the profession on the bar and bench be invited to read the booklet if it was the authentic one, and ask for comment on it, suggest amendments and corrections for your Lordship to consider and promulgate, so that the profession can be saved from the hands of fake news publishers, to the fake publishers of books and court papers, and enhance the administration of justice in the country. Finally, my Lord, we are all Nigerians, and I believe firmly that your Lordship and the judges of this country fall within the same class of citizens who cannot relocate to settle in any other part of the world. If therefore, it is therefore our responsibility to work to enhance the society in which we shall spend the remaining part of our God-given lives. This duty entitles me to say a word or two of the state of our nation, without going into politics or politicians. My Lord, when I was young, I studied economics to the GCE ordinary level. In the study of economics of the time, we were taught that the monopoly that left the business in the hands of one person is not good for the economy of the country. It is not healthy for the country's economy. So in England, in the 60s, I saw efforts made to discourage monopoly. The judiciary does not manage or control the economy. I know that. If the hunger and hardship pervading the country at this time is allowed to continue for another 1 year, the rich and the poor will not be able to move. So the judiciary and the legal profession will not stand idly by or on the issue of hardship, hunger, and poverty. The bar should speak out, look vocally, so that the ordinary man and woman and child in Nigeria will understand the hardship everyone is going through. We are all suffering it. We will work together. To see if it can be averted. Our appeal in public and in private will be directed at this. So, it is needful that we don't keep silent. Let no one rock the boat of our nation. Let everyone be reasonable and be disciplined, because there must be an acceptable solution for the country. My Lord, I thank you. Thank you, my Lord.
Thank you very much, Chief Okoko.
Thank you.
And I'd like to assure you that the authentic copy of the rules of the Supreme Court has not yet been in circulation. It will be in circulation with effect from the 2nd of October. So whatever is in circulation now is not the authentic copy of the rules. Thank you. I'll now invite the President of the Nigerian Bar Association, Mazi Alpha Mosigwe, Senior Advocate of Nigeria, to give us his remarks.
My Lords, may I adopt the already established protocols so that I save time. When we gather together before your Lordships on a day like this, we gather to celebrate the personal achievements of those joining the rank of Senior Advocates of Nigeria. We gather to reaffirm our collective commitment to advancing the administration of justice in Nigeria, even as we mark the formal opening of this course legal year, and then we celebrate the appointment and swearing in of Honorable Justice Kudirat Motomori Olatukumbo Kekereku CFR as the 19th Indigenous Chief Justice of Nigeria, the 23rd Chief Justice of Nigeria, and indeed, the second female Chief Justice of Nigeria. I therefore, at this point, congratulate your Lordship on your appointment and swearing in as the Chief Justice of Nigeria. From the answers your Lordship gave at the Senate confirmation hearing, we believe that efficiency, transparency, and accountability will be your watchword. The NBA believes that in title alone, your Lordship will be called Chief Justice of Nigeria. But in nature, conviction, vision, practice, and action, you remain a reliable jurist and a friend to professional colleagues, regardless of status, age, niche, or origin. I believe you improve the standing of the Nigerian judiciary, proactively address issues affecting administration of justice, enthrone the appointment of judicial officers devoid of influence by politics, personal relations, connections, or status, and fashion ways to promote the protection of the rule of law. The opening of the legal year is a time for reflection, renewal, and rededication to the values of justice, fairness, and the rule of law. It provides an opportunity to acknowledge the work done by the judiciary in the past year, while also looking forward to the challenges and opportunities that lie ahead. The opening of the legal year is consequently more than a ceremonial occasion. It is a moment when we, as officers of the law, pause to reaffirm our dedication to upholding justice, ensuring the rule of law, and protecting the rights and freedoms of Nigerians. The judiciary is, after all, the bedrock of our democracy, and it is through the work that your Lordships do here and the lawyers who appear before you contribute in doing that justice finds expression in the everyday lives of our citizens. The legal year ceremony is coming at a time when, to borrow the words of a past Chief Justice of Nigeria, Honorable Justice Dahiru Mustafa of blessed memory, as it stands today, it appears that the society is not entirely satisfied with the performance of the judiciary. One may wonder why we should bother about the public perception of what our courts decide. Some may insist that public opinion is inconsequential and that the courts or the legal profession should not be bothered about what the public think or make of court judgments. Supporters of this viewpoint remind us that the law is what the courts say it is. Persons who subscribe to this school of thought argue that the law is not what the statute books say it is, but the law is what the judges say in their judgments that the law is. Those who demur insist that perception is stronger than reality. And we use an anecdote to help drive home the point that we should not pretend that perception should be ignored. The illustration goes thus. Several years after leaving secondary school, a man met one of his schoolmates and could not believe his eyes. His friend was driving a brand new shiny sport utility vehicle. The man went home feeling he had failed. He was very disappointed in himself. He thought he was a failure. Unknown to him, his schoolmate was a driver and had been sent on an errand with his boss's car. He had been fooled by his perception that his friend was the owner of the vehicle. This story reminds one of what an anonymous writer once said, that with reality, there is not much room to maneuver. With perception, we can exaggerate or modify according to the need. Perception is therefore of utmost importance as much as reality. While we must ultimately be concerned with reality, we should not feign indifference to how we or actions are perceived by others, especially the public. We believe this is of utmost importance in the administration of justice. In this instance, the perception of the public about decisions from electoral cases. As stated by Lord Hewart in R and Success Justice's ex parte McCarthy, citation supplied, where he observed that what was important was not what was actually done, but what might appear to have been done, and he held, nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. Problems arise when people's expectations are not met by court decisions, or when they go away, not believing that decisions of course are either justified or correct. It is equally worse when people believe that court judgments are bereft of justice. Having made this point about the imperativeness of not ignoring public perceptions about decisions of our courts, I must remind us that there is a growing perception by more Nigerians that judicial officers are oftentimes appointed without regard to merit, that our courts do not give justice, that our courts waste a lot of time, that are corrupt or do not protect the indigent, as the rights and interests of the citizens are oftentimes not prioritized. The negative perception about judicial decisions appears to be highest, like I've noted earlier, with regard to judicial decisions in electoral cases. I therefore agree with late Honorable Justice Dahiru Mustafa when he further said that hard as it may be to accept, we feel it is less important to focus on whether this assessment is fair or not. The important thing is for us to transparently come to terms with the prevailing realities, accept the gap in expectations, and do our utmost best to bridge it. Notwithstanding a negative perception, I must admit that our courts have done creditably well, but we go further to admit that a lot more could still be done. This is because no matter how good anything or situation is, there is always room for improvement. A revered past president of the NBA, J.B. Daud Sen, who incidentally is in court here today, once said that the judiciary has had its share of the good, bad, and ugly, but it still remains the last hope of the common man. The judiciary is a gum that binds society to prevent a situation where every family or street will have a warlord whose sense of justice is determined by his temperament. The judiciary must be alert and proactive in ideas and actions, unquote. As we take a moment to look back on the previous year, it is important to acknowledge the remarkable resilience and unwavering commitment displayed by the judiciary in the face of numerous challenges. Our courts have demonstrated unwavering dedication in adjudicating cases vital to the stability and progress of our nation. I pause to note the local government autonomy case decided by this court, which the Honorable Attorney General of the Federation had referred to earlier in his speech. However, it is crucial to address the significant difficulties that continue to hinder the administration of justice in Nigeria. One of the most pressing concerns is the persistent issue of delays in justice delivery. For many years, the pursuit of justice has been arduous and protracted. These delays, often attributed to overburdened court system, procedural bottlenecks, and insufficient resources, erode public trust in the judiciary. As we embark on this new legal year, it is imperative that we collectively renew our commitment to addressing these inefficiencies. It is unacceptable that many Nigerians, particularly those from rural or marginalized communities, are unable to access the justice system due to geographical, financial, or procedural barriers. Former Chief Justice Mohammed Lawal once remarked, for a judiciary to function effectively, it must have the trust and confidence of the people. But trust in the judiciary is only possible when people believe that justice is accessible and attainable. We must therefore explore innovative solutions to make justice more affordable and accessible, such as the greater use of alternative dispute resolution. I'm also glad to note that Your Lordship, the new CGN, had promised to make this work. We also ensure that we digitize our court processes. Another pressing area of reform is a reduction in the backlog of fake cases. The reality is that our courts are overwhelmed by the sheer volume of cases, leading to significant delays in justice delivery. As a nation, we must embrace the modernization of our court system, including the use of technology to expedite case management and reduce unnecessary delays. We must also reduce the number and types of appeals that come to these honorable courts. At the bar, we shall advocate for computerization of litigation process, including recording of court proceedings in all superior courts of record. We will also propose judicial reform in the following areas: case management and scheduling with time slots, notification to lawyers of adjournments, enforcement of the use of MBA email address in the filing of all process, and customized email address for all courts to ease communications to counsel and litigants who appear before the courts. It is our expectation that under Your Lordship's leadership of the NJC, National Judicial Council that is, NBA shall work with the NJC and various heads of court to ensure effective utilization of the legal mail project initiated by the NJC, as well as work for the commencement of electronic filing and payment platforms for all superior and appellate courts in Nigeria to end the unnecessary costs, delays, and inefficiencies encountered in filing processes in our courts. We also hope that such collaboration will lead to amendment of various laws and rules of court to accommodate electronic methods in conducting activities in courts, filing and service of processes, as well as hearing of matters and applications. I am told that a lot can be learned from South Korea and other developed countries, which have fully embraced the electronic method. We know that the Supreme Court Rules 2024, which has consolidated all relevant rules and practice directions into a single accessible body of rules for the court and legal practitioners, has blazed the trail in this regard. My lords, we also hope that Your Lordship's leadership of the NJC will ensure that the chief judges of the states and the FCT make sure that all police stations and other detention facilities in each state of the Federation and the FCT are visited and inspected by magistrates and judges once a month, in accordance with the provisions of the Admission of Criminal Justice Act and laws. We also hope that the number of inmates in our correctional facilities, which was recently put at about 73% of the total prison population, will be greatly reduced if the abuse of holding charge is addressed. We urge the NJC to work with heads of courts to ensure that no court, and we emphasize no court, makes a remand order without taking steps to ensure that a charge is filed against a person against whom such an order is made, and that such a court makes an order for periodic review of the remand order to know whether there is need for the continued retention of the order, or whether the court should make an order that such a person be admitted to bail or charged to court within a specified period of time. The courts no doubt have a role to play in making sure that no person who has no reason to be in detention is incarcerated. It is believed that thousands of citizens are suffering in unlawful custody in many detention facilities and centers in all states of the Federation. We all therefore have a crucial role to play in monitoring and ensuring that the requisite authorities carry out their statutory duties of inspecting police stations and other detention facilities in various states of Nigeria and the FCT. May I digress to humbly request the Chief Justice of Nigeria as the Chairman of NJC to take steps to end the current trend of making the swearing in of judicial officers a huge fanfare filled with pomp and ceremony. We are of the view that the overly lavish ceremonies we now see being organized by such newly sworn judicial officers is robbing the offices they occupy of the solemnity and discreet nature they deserve. Both the swearing in and celebrations should be private, while receptions should be court-sponsored luncheons for the newly sworn judicial officers. May I pause to note that it also unduly exposes newly sworn judicial officers to politically exposed persons, and I wish that your Lordship would consider making a practice direction or some direction to judicial officers in this regard. The judiciary must show a reluctance to mimic the public exhibition of affluence and public celebrations. Having said these few words, I will now congratulate the new senior advocates of Nigeria. I need not remind us that conferment of the rank of senior advocate of Nigeria is a recognition of your outstanding merit and excellence in the legal profession. The rank is not given lightly. It is earned through years of hard work, dedication, and an unwavering commitment to the practice of law. The rank of senior advocate of Nigeria is more than a title. It is a call to serve as a leader within the legal profession. As senior advocates, you are now the custodians of justice. You bear the responsibility of upholding the highest standards of legal practice, ethics, and integrity. It is crucial to recognize the importance of mentorship within the profession. Your role is not confined to personal excellence. You are now expected to mentor younger lawyers, inspire them through your example, and champion the cause of justice both in and out of the courtroom. The younger lawyers look up to senior lawyers and senior advocates for guidance, and we must provide that leadership. In this new chapter of your professional life, I encourage you to invest in the growth and development of junior lawyers. And I'm glad that my Lord, the CJN, has mentioned it. We must make sure that we pay the younger ones who work with us well and treat them well too. Through your mentorship, you can help shape the future of the legal profession, ensuring that it remains vibrant, ethical, responsible, and responsive to the needs of the society. The prestige of the SN title places you at the forefront of the legal profession. With the privilege comes a greater duty to safeguard the sanctity of our legal system. In a world where challenges to justice and equity are ever present, your voice must be heard in the pursuit of legal reforms and social justice. You have the power to influence policy, advance legal thought, and lead the charge for greater accountability in governance. You must live by example. I therefore urge you to see this opportunity to contribute much more meaningfully to the development of our nation. As we gather here today in this solemn ceremony, we therefore recognize the achievements of those who have shown exceptional skill in advocacy and exemplary professionalism. By joining the inner bar, you are being acknowledged not only for your success in the courtroom, but for your service to the legal community and society at large. But as with all great honors, this achievement comes with heightened responsibility. Today marks not just the recognition of your past efforts, but beginning of a new journey that calls for even greater commitment to the rule of law and the administration of justice. We will not end this without calling for a review of the guidelines for the conferment of the rank of senior advocates. As it would appear, the current guidelines precludes academics who teach in the Nigerian law school from applying for and obtaining SEM. They are not professors, they don't supervise projects, so they can be considered as academics. The possibility of considering the number of academics who are equally awarded the rank to about 3 should be considered. We also suggest that the Legal Practitioner Disciplinary Committee Rules 2020 should be amended not only to speed up the disciplinary process, but also ensure that the Legal Practitioner Disciplinary Committee focuses only on adjudication and not combines same with investigating and determining whether a prima facie case has been made out before a respondent is called upon to respond to a petition. NBA is ready to work with the body of benchers and the Chief Justice of Nigeria to amend the LPDC rules to particularly fully restore the role and powers of the NBA in the investigation of complaints or professional misconduct against legal practitioners, as well as prosecution of matters before the LPDC. Finally, I know that as lawyers, we have a duty to support the judiciary in the delivery of justice. This requires that we approach our work with diligence, integrity, and respect for the court's processes. The NBA is fully committed to collaborating with the judiciary to address these challenges, whether through advocating for judicial reforms, promoting continuing legal education, or enhancing access to justice. The NBA remains a steadfast partner in the advancement of the rule of law. As we look forward to this new legal year, let us do so with a renewed sense of purpose and responsibility. We must confront the challenges before us with courage and determination, and always keep in mind the words of late Justice Taslim Elias, that justice is the greatest concern of man on earth. The legal profession has a unique role to play in shaping the future of Nigeria. We are custodians of the law, and it is through our collective efforts that we can build a justice system that is fair, efficient, and accessible to all Nigerians. We must therefore dedicate ourselves to the cause of justice, as we have an enormous responsibility to uphold the rule of law and ensure that our judiciary remains the last hope of the common man. I pledge the NBA's continued support for the judiciary and its unwavering commitment to improving the administration of justice in Nigeria. Let us therefore move together into this new legal year with renewed determination to uphold the rule of law and to build a stronger and more just Nigeria. Thank you so very much.
Thank you very much, President of the NBA. Last but not the least, I will invite Lateef Karim Olaseyinde, Senior Advocate of Nigeria, to present his remarks on behalf of the new Senior Advocates of Nigeria.
I noticed some corrections. Yes,
Good afternoon, my Lord. May I, with respect, be permitted by my noble Lord, the Chief Justice of Nigeria, to rest on the protocol so articulated and established by my Lord, the Honorable Chief Justice of Nigeria, Honorable Justice Kudirat Motomori Olatogunbo Kekere-Ekun, CFR, and followed by the honorable speakers before me. My lords, we made history in this country in the precinct of these hallowed chambers, where my Lord, the Chief Justice of Nigeria, administered the oath on the 87 new senior advocates of Nigeria, including my humble self, about an hour and a half ago. Talking about history, last week, Wednesday, the 25th of September 2024, history beckoned when my Lord, the Honorable Chief Justice of Nigeria, was confirmed as the substantive Chief Justice of Nigeria and subsequently sworn in this morning, 30th September 2024. My Lord thus became the 23rd Chief Justice of Nigeria and the second Nigerian female jurist to serve in this position after His Lordship Justice Aloma Mariam Mukhtar, who was Chief Justice of Nigeria between July 2012 and November 2014. I'm sorry, my Lord, the gloves are not allowing me to open the pages. Thank you, my Lord. My Lord, the Chief Justice, on behalf of my brother Silk, I congratulate my Lord and wish your Lordship a most auspicious tenure. Let me also, on behalf of my privileged colleagues, humbly and gracefully thank the Almighty Allah, to whom all praises and adoration are due, and whose special grace made today's ceremony a reality. For me personally, today is a confirmation of the saying that God's time is the best. I am particularly humbled by my Lord's invitation to me to present this address and vote of thanks on behalf of all the 87 legal practitioners newly conferred with the prestigious rank of Senior Advocates of Nigeria. We cannot but recognize and thank the former Chief Justice of Nigeria, my Lord Justice Olukayode Ariwola, GCON, whose burden the exercise of producing us, the new senior advocates of Nigeria, was on. Between March 1st, 2023 and July 2024, we profusely thank my Lord Justice Oluka Odariola GCON for accepting the recommendation of the distinguished members of the Legal Practitioners Privileges Committee that my brother Silk and I be elevated to the very prestigious, cherished, and enviable rank of the Senior Advocates of Nigeria. We must also thank the vessels through whom it pleased the Almighty to crown our efforts with success, principal among those human vessels are our judges and justices of all the superior courts before whom we appeared and argued our cases over the years in the pursuit of this achievement and crowning glory of today. Let me also hasten to thank our respective family members who supported us with love, affection, and prayers throughout the grueling period of the process that resulted in our appointment, the conferment of which we are witnessing today. My Lord, in addition to the oath we took before your Lordship this morning, we promise to live up to the expectations of all men and women of goodwill who are gathered here today to witness this great occasion, and indeed the expectations of all well-meaning Nigerians. Kindly permit me use this opportunity to commend my Lord Justices of the Supreme Court on the recent groundbreaking judgment on the autonomy of local governments in Nigeria. It is my firm belief that the decision is a significant milestone in turning the tide of grassroots development for the better in our nascent democracy. As senior advocates of Nigeria, we pledge to continue to be leaders of the bar and mentors to our junior colleagues. We shall make integrity, courtesy, punctuality in court, as well as brevity in presentation of cases in court our watchwords, thus positioning ourselves as role models for the profession. Whilst we acknowledge that the rank just bestowed on us this morning is a privilege to which is attached a higher degree of responsibility, we pledge to lead by example by being industrious, respectful, and disciplined. We recognize that we represent the voices of those who have no voices. Thus, our daily endeavor will be to maintain high standards of industry and advocacy. We promise to maintain a high degree of decorum as well as ethical and moral standards. We shall continue to be subject to the rule of law, speak for and defend the bar as well as the bench at all times. We shall also defend the cause of justice in accordance with the law. Finally, my Lord, Lord Justices, and all men of goodwill here present, I have been requested by my learned brother Silk, to appreciate everyone who played one role or the other in assisting us attain this enviable height today by using my Lord as points of contact. Above all, we thank the God Almighty who preserved us all and made today a reality. May the Almighty bless us and prosper us all. We thank you. We wish you journey mercies back home. Thank you. Grateful, my Lord.
Thank you, Mr. Lateef Karim Olasaide, Senior Advocate of Nigeria. And on that note, our legal year comes to a close. We thank you all for your patience. We thank you for your understanding when the timing had to be changed. We know that you have family waiting, eager to celebrate with you. We thank you very much. The Chief Registrar has a few housekeeping announcements to make. Thank you.
I have the permission of the Honorable the Chief Justice of Nigeria to announce that the instrument of conferment will be presented to the conferees in a future determined date. And the date will be communicated to you as so and it is done. And also that there will be refreshment. The refreshment will be served at the justice entrance for a foyer for invited guests only. Thank you. The court to rise. Please be silent. Let the justices go, please. Can't you see I'm talking? I'm badly stressed. Have some mercy. How can you be talking to me? I said when I want to sleep.